name is June Venters, and this is my colleague, Elsbeth Wells. We are both accredited family mediators. This is Family Mediation Week, and we wanted to take the opportunity to make this short film to explain a bit about mediation to you. And we thought it would be helpful for Elsbeth to ask me some of the typical questions that prospective clients often ask both of us. So over to you, Elsbeth.
So June, I think clients want to know, what issues do you cover in mediation?
In family mediation, we usually cover relationship breakdowns, and that can be, for example, separations, it can be divorce, and it can involve finance and children.
Thank you, June. And I've heard of a mediation information and assessment meeting. What's that?
Yes, it's usually known as a MIAM. Very briefly, that's the initial meeting that a member of the public would have with a mediator in order to determine whether or not they should enter into the mediation process. And the way that that meeting is arranged, the mediator will ask a series of questions to assess their suitability, but at the same time, they will also be providing to them information about the process itself.
And what are the core principles, the main things about mediation clients should be aware of?
Firstly, it's voluntary, and that's extremely important because nobody can be forced to come into mediation. It is necessary in a lot of situations, unless usually it's an urgent situation or one involving risk, that if you want to issue court proceedings in family matters, you do have to meet with a mediator for that initial meeting. But that's as far as it goes. If after that you're assessed as suitable, you still cannot be forced to go into mediation unless you agree to do so. So that's a core principle and a very important one. Another core principle is that the process is confidential. So anything that is discussed in mediation is never disclosed outside of mediation unless both participants agree to that. Another very important principle, and one that I think is very important to remember, and that is that a mediator never takes sides. The mediator is impartial, and they are there to facilitate the communication between the two participants. So unlike, for example, having a solicitor who would be taking sides because they're acting for one person against the other, that is not the role of a mediator at all. And finally, what I would say is a very important core principle is that the decision that is made in relation to the outcome is one that is made by both participants. And that is a very big difference to going through the court process, where of course it is the judge that makes the decisions. And very often someone will leave with what they consider to be the right decision, and the other person will leave believing that the decision was wrong.
Thank you, June. So if somebody's watching this and they're thinking, oh, I don't know about mediating, this sounds like I've got to sit with the other party and I'm scared of them. What about people who are in that situation, June?
That's a very frequent question and a very obvious question in situations where there has been, for example, domestic violence. Not every case is suitable for mediation, and some cases where there has been domestic violence, it may not be suitable. But having said that, many cases are. And the reason for that is that the mediator is able to ensure the safety of both participants. And they do that in a variety of ways. Firstly, they can offer what's called shuttle mediation, which means that the two participants do not meet in the same room. They do not meet at the premises at all. They are kept separate and apart. And the mediator goes between the two of them. And also, what is also very, very important, every mediation service has to provide a safe environment And that's a conduct rule that we all have to abide by.
Thank you, June. What about clients who ask, well, is this just a discussion about what we want to do? What happens with any agreements we come to? Can you make them legally binding, or is this really just an understanding?
It again depends on what the individuals want from the mediation process. But ultimately, what the mediator will do is help both of the participants to come to an agreement. When that agreement has been achieved, a document will be drafted. It's known as a memorandum of understanding. And if both participants are happy to rely on that agreement, then that's as far as it goes. It's not legally binding. If, on the other hand, they want to make it legally binding, then that can be taken, if they wish to do so, to a solicitor, who in turn can apply for what is known as a consent court order, and that then does become legally binding.
What about people who are thinking, well, I don't know what to say in mediation. I'd prefer my solicitor to come and speak for me. Does that ever happen?
It is possible for solicitors to accompany participants to the mediation process, providing both of them agree. And again, this is something that isn't commonly known among members of the public, but ultimately, if someone wanted to bring a solicitor, I know, to a mediation that we were conducting, we would not be opposed to that, providing both participants were in agreement. But the important thing to remember is that the solicitor wouldn't be there to represent their client. Mediation is not a court forum, it's not arbitration. They would be there simply to advise each participant that they were there to accompany, but ultimately the discussions would be conducted by the participants with the help of the mediator.
And June, parents watching this who are concerned because their son or daughter may have said to them, well, I already know what I want. Do they have a voice? Absolutely.
In both the mediation process and the court process, we say that it's the voice of the child, and the voice of the child has to be heard. The child's welfare is always paramount in both processes, court and mediation, and we observe that in mediation. Ultimately, so far as involving children are concerned, the first thing that we would do is talk to the parents about that. They both would have to agree that they would want the child to speak to the mediator, and then we would contact the child, usually in writing, with the parents' full agreement and approval of anything that was sent to them, inviting them to join in the process. And then what would happen is that they would meet with the mediator if they chose to do so. But the core principles that apply to adults applies to them, and that includes confidentiality. And so if they didn't want what they had said to the mediator to be shared with their parents, then that has to be observed. Unless, of course, it was something involving risk, then that would obviously take that outside confidentiality.
Thank you, June. So how much does mediation cost?
It depends if someone is eligible for legal aid. If they are, they need to ensure that the mediation service has a legal aid contract and can offer legal aid, and not every mediation service has that facility. If they're not eligible for legal aid, they would have to fund it privately, and that very much depends on the procedure adopted by the particular mediation service. I know from our perspective, we organise that by way of a sliding scale, dependent on income and capital.
June, I've heard about a voucher that's available for child issues. Is that true?
It is. It's a government voucher that is available. The mediator has to apply in order to obtain that. But at the moment, it is available and is up to a maximum of £500. But it does only cover those cases where children are involved in the mediation process. And I don't mean actively and physically involved. I mean the mediation itself has to involve both children and other matters, or just children.
So it sounds like a great time to start mediating if you want to, if there are child arrangements at the moment. So how long does the process take, June, for mediation?
The average number of sessions we say is usually between 2 and 5, and they last usually about an hour and a half. But as with every situation, sometimes the norm doesn't apply and we have to go outside that. But that's the average. Okay,
June. And so now, summing up, what's the overall benefit of mediation in your view?
The overall benefit, in my view, is that the participants to the process are the decision makers. Unlike when they go to court, the judge makes the decision. And as I've already said, that means usually they are not both happy with the outcome, whereas in mediation, we aim to achieve something that they can both live with. And as with any agreement, usually it's much more likely to work than something that's imposed on someone. So that's a very important benefit. There's no doubt that it's more cost effective, particularly if you compare that to going through the court process and having a contested hearing. It's a much kinder process. In mediation, we have a very strict set of rules that we ask the participants to observe, which usually means about behaviour towards one another in the process. Whereas in court, a lot of people do find that being cross-examined can be a very difficult process for them to have to go through. They're very often asked very embarrassing questions, questions that they have great difficulty answering. So the whole process compared to court is usually much kinder.
Thank you, June. That's been really helpful, I think.
Well, I think we both agreed, Elsbeth, that it would now be helpful if you explained the type of cases that you and I have both dealt with over the years and your experience of how they have developed and the outcomes that have been achieved.
Thank you, June. So yes, I mean, I would say that most commonly as mediators, we meet clients who have some financial issues as well as child arrangements to resolve. Not always, as you said earlier, but it's my experience, and I'm sure yours too, June, that clients find the mediation process a very safe environment generally to both talk about their own worries and hopes, and of course spend time listening to the others, which they may not have done before. We aim to help the clients navigate the difficult journey through the balance of legal, financial and emotional issues, hopefully to a point of resolution. Where there are child arrangements, it's important to ensure that parents focus on trying to agree what is in their children's best interests and what's actually going to work practically for them as parents too, considering their own lives, work commitments, and even in time, new partners. We tend to get a lot of feedback about how much money the clients feel they've saved by going through mediation. I think it's helpful to say that we've had a great deal of success in mediation cases generally, and people leave the process feeling much more able to work together, particularly when they need to continue to co-parent their children. And June, isn't it such a real privilege to watch clients move from a position at the start of mediation where they do not believe they can find any common ground at all to a point where they find solutions that work for the whole family going forward?
Absolutely, and I think that you would agree with me, Elsbeth, that at Ventus we have feedback forms that we ask to be completed, and it's very, very heartening to see some of the comments that have been made, and that essentially is something that we take very seriously.
Yes.
Well, thank you so much for explaining your experience, and we hope that this short film has given you a little bit of insight into mediation, but please do feel free to contact us should you have any questions that you wish to raise. Thank you.
Thank you.